The debate on whether mental disorders are biological diseases or deviations from societal norms goes as far back in history as the ancient Greeks. We hear it every day, the word insane used not only out of context, but used completely wrong. That's insane, or are you insane, are common phrases utilized when we think something is absolutely ludicrous and crazy. Insanity is actually a legal term, used to define the competence of an individual to stand trial. It is important to know that insanity is not a psychological term. It is not definitive of having a mental disorder, nor is it used by psychologists in any situation except for in the courtroom. Over the course of history, specific laws have been put in place to protect the rights of individuals in the courtroom. The development of this protective plea term began as early as the Golden Age of Greece, around 500 to 300 BC, when the Greek philosopher Plato addressed madness in his dialogue Phaedrus. Jump to hundreds of years later, we see classifications added to the insanity defense. A person can be accused of a crime and can acknowledge that they committed the crime, but argue that they are not responsible for it because of their mental illness, by pleading not guilty by reason of insanity. The insanity defense is classified as an excuse defense, meaning the defendant who committed the action is excused because of a prevailing condition, in contrast to justification defenses like self-defense. The first legal assessment for criminal insanity was seen in 1843 in the M. Naughton case. An Englishman named Daniel M. Naughton shot and killed the secretary of the British Prime Minister because he believed that the Prime Minister was conspiring against him. The court acquitted M. Naughton by reason of insanity, and he was placed in a mental institution instead of jail for the rest of his life. The M. Naughton rule is now a standard to be applied by the jury after hearing medical testimony from prosecution and defense experts. The rule created a presumption of sanity unless the defense proved, at the time of committing the act, that the accused was laboring under such a defective reason from disease of the mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. The test is broken into two components. The first component involves determining whether the defendant is insane, whether they know what they were doing at the time of committing the offense. A defendant is not culpable for an act that, because of a psychological infirmity, he or she did not know he or she was committing. The second component of the test looks to determine if the defendant knew that his or her actions were wrong. Here, even if the defendant knew what he or she was doing, he or she is deemed insane where he or she was incapable of recognizing the wrongfulness of the action committed. An example of when this test is utilized is when the defendant is often found insane on the grounds that, because God commanded the defendant to act, he or she was unable to recognize the wrongfulness of the act that was carried out. There are many theoretical issues with the McNaughton framework. By focusing exclusively on cognitive incapacity, the McNaughton test is not well suited for treating more nuanced forms of psychological disorders, particularly those involving volitional impairment. Traditionally, the McNaughton test has been associated with schizophrenia and other psychotic disorders. The McNaughton rule became the standard for insanity in the United States and in the United Kingdom, and it is still the standard for insanity in almost half of the states in the U.S. The McNaughton rule was not universal for all mental disorders, so later, in 1929, the irresistible impulse test was designed. This test was designed for criminal defendants who, while comprehending the wrongfulness of their actions, are incapable of self-control because of a mental disease or defect. It should be noted that the irresistible impulse test is now not applicable in federal courts, and most states have ruled it as inapplicable. Later, in 1972, in an attempt to modernize the legal standards for insanity, the American Law Institute, a panel of legal experts, developed a new rule for insanity as part of the Model Penal Code. This new rule declares that a defendant is not responsible for criminal conduct where they, as a result of mental disease of defect, did not possess a, quote, substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. Providing that the defendant meets these requirements, they receive a not guilty by reason of insanity verdict, and the insanity defense allows a sentence substitution of psychiatric treatment instead of serving time in jail. There are many critics of this defense. Those against it say that too many sane defendants use the NGRI to escape facing the consequences of their actions. However, the not guilty by reason of insanity plea is rarely utilized and often only used as a last resort. According to the Huffington Post, a 1991 study done by the National Institute of Mental Health found that the insanity plea has only raised in about 1% of all criminal cases, and of those, only about 1 in 4 was successful. However, considering that the Bureau of Justice Statistics found that 61% of state prison inmates had either a recent history or current symptoms of mental illness, despite popular belief, the relationship between mental health and crime suggests that more inmates could use the benefit of treatment rather than being put behind bars. The rarity of the not guilty by reason of insanity plea being entered is likely related due to the complexity and cost associated with such a case. An NGRI plea in California increases the cost and length of a criminal trial. The experts obtained by the defense attorney as well as those appointed by the court must spend time with the defendant, evaluate past medical records, and give testimony potentially twice. Because of this, the attorney may not even have the time or ability to even get past medical records and analyze if a defendant is a good candidate for the NGRI plea. Now, I wanted to mention 3 of my favorite notorious insanity cases. The first being John Wayne Gacy, who was convicted in 1980. According to PBS, John Wayne Gacy was arrested in December of 1978 in Illinois after being suspected of being involved with the disappearance of a 15-year-old boy. The resulting police investigation unearthed the skeletons of over 30 youths from a crawl space beneath his home. Some of Gacy's victims had managed to escape, and at his trial they testified that Gacy had lured high school students and male prostitutes to his home where he would rape and torture them. Gacy admitted to these killings, but however pled insanity. The jury rejected this plea, and Gacy was convicted and sentenced to death. He was executed in 1994. The second case involving the insanity defense is in the case of Jeffrey Dahmer. In 1991, Jeffrey Dahmer was convicted of the murder of 15 young men whose mutilated, cannibalized bodies had been found in his Milwaukee apartment. Dahmer reportedly had sex with the corpses of many of his victims, attempted to perform crude lobotomies on others while they were still alive, and stored body parts in his refrigerator to be eaten later. At trial, he admitted the killings, but pled not guilty by reason of insanity. His plea was also rejected, and the jury found Dahmer to be legally sane at the time of the murders. He was sentenced to 15 consecutive life sentences without chance of parole. The Dahmer conviction was hailed by many as the death of the insanity defense, and a counterpoint to the Hinckley acquittal. If such a clearly deranged killer could not be found legally insane, it seemed unlikely that the defense would ever be successful, at least in a high-profile case involving a violent crime. Dahmer was killed in prison by another inmate in 1994. Lastly, Andrea Yates, who was found not guilty by reason of insanity in 2001 after drowning her own children. It was the second time that Miss Yates had been tried for the deaths of her children in a long-running case that has highlighted the issues of postpartum depression and the insanity defense in the Texas legal system. On the morning of June 20th in 2001, Mrs. Yates filled a bathtub with water, police court records show, and drowned her 5 children in the family's bathtub one by one. She told police that Satan was inside of her and she was trying to save them from going to hell. Mrs. Yates, whose lawyer said she was suffering from severe postpartum psychosis when she drowned her 5 children, aged 6 months to 7 years, will likely spend the rest of her life in a state mental institution